I was saying that as soon as Charlotte Osei was removed on those grounds, we had already set the standard for removal of Superior Court judges. And that standard should not be any weightier than just a breach of procurement law. And so if someone is alleged to have breached the Constitution, which is bigger than the procurement, than any statute, we can now not be asked to listen that to an argument that such a breach is not sufficient or is less grievous enough for a removal of a Superior Court judge. And as I said, it was not only Charlotte Osei. This lady called something Lamte, who was the Siraj boss,
Yes.
was removed on similar grounds. And then Justice Derry was removed from office on some grounds. Justice Essel was removed from office as a Superior Court judge on some grounds. So, if these grounds could warrant the removal of those members of the Superior Court, why are constitutional breaches being alleged? And we are made to now listen to argument that constitutional breaches are less grievous. Are we to understand that constitutional breaches are less grievous than breaches of statutes, than a breach of a procurement act? No, I don't think it is so. For me, so I think that, look, and I'm not saying that the Chief Justice must be removed or must not be removed. No, that's not my point. The point is, we have chosen a constitution for ourselves. And that constitution constitutes a social contract among us inter se and between us and our government. And that is why each official of government created by the constitution has to go through some form of taking an oath. If you look at all the organs of government, they take an oath which is prescribed by the constitution. And that is a confirmation of the contract. That's a seal of the contract between us and them, that they will protect, they will preserve, and they will defend the constitution we have chosen for ourselves and by which we have created their offices. Okay? So it is our fidelity to the constitution that should matter to us. And it doesn't matter who it was. Even if it were not Justice TORKORNOO, I would have still made this argument that it is not about her person. It is about the constitution. It is about stated misbehavior. It is about incompetence. So if the facts that are alleged do not yield any of these outcomes, then of course she remains in her office. But if the facts actually alleged yield the outcome that she misconducted herself to the extent of meeting the requirement of stated misbehavior or the requirement of incompetence, why should anybody think that her removal is an attack on the Chief Justice or on the judiciary? In fact, the judiciary suffers if the head of that judiciary is tyrannical and is misbehaving or is incompetent. The judiciary rather suffers. So it is not about the person of anyone. And I will say that, look, my personal encounter with this the suspended Chief Justice on cases that are unrelated to politics, you will find, most people will tell you that she was very incorruptible. That's my personal opinion, and I would have spoken for her in this. But the subsequent events that we have witnessed upon her ascension to the Supreme Court has made all that look to us like it was a ruse. And so for me, it is not about her person. It is about the facts and the evidence being led. whether they meet the threshold, the constitutional threshold of stated misbehavior and incompetence. That's all. And I think lawyers and professionals should focus on that. And once, for me, my personal opinion is that once a breach of statute called the Procurement Act was deemed by a similar committee to meet the threshold of stated misbehavior and incompetence, it should remain the standard. And the breach of constitution cannot be deemed to be any less in gravity. That's my personal opinion.
And like I said, to conclude, then there is the matter against Godfrey Adami. And I'm sure you expressed your opinion when this matter of the Jakpa tape came up. Finally, somebody is is moving on that to ask the General Legal Counsel to act. A little too late?
Well, it's not too late. It is not too late. In fact, it couldn't have been brought at a better time, because at the time the things happened, he was the Attorney General of the Republic, and perhaps people will say he had conducted himself in that manner in the course of public duty and all that. And so, for me, this is the best time. But for me, once again, it is not about his person. It is about what he has done, and whether we as a people in our constitution expect that, in our laws, expect such a person to do that, expect a lawyer to do that. We have laws governing the profession, and those laws are being implemented every day, almost every day. People are losing their licenses because of one conduct or another against people. So there is a standard for every office and for every profession. So definitely, Godfrey Adami is a member of the legal profession. And in fact, as an Attorney General, he had risen to the head of that profession before. And so if any law prescribes anything, he must be the first to submit himself to that law. You will always listen to the president and the president of the Republic in his in his oath of office saying that he himself will submit himself to the Constitution if he happens to do anything against it. So that should be so if he was the president, was the leader of the bar, and there is a law regulating the conduct of the members of the bar, and someone is alleging that he's found himself foul of the law, why wouldn't it go through the same process everybody goes through? So he should. I think it is in the right. It is in order, because what we actually heard, and always I don't as a lawyer, I don't always believe everything I see in social media or I hear people say or I hear the media say without my personal way of verification. Yes, I have not verified those facts, but if they are indeed true, it is not befitting of an Attorney General. It is not. And so I think it is necessary. It is important for the General Legal Counsel to go into it, inquire those facts, and evaluate the evidence, and if they are true, take the appropriate measure as they would have taken against any lawyer if it were not the former Attorney General.
Thank you. Just that there's a listener who disagrees with you when you said your colleagues should stop. In fact, I think he says that he's actually enjoying the banter and the language being used in the banter. So he disagrees with the suggestion that they should. In fact, this is Lulu Mensah. Lawyer, why are you saying they should stop? I'm enjoying the literature. That he's learning quite a lot from. But thank you. Thank you very much for speaking to us.
No, we are not allowed, professionally. It is a sign of we are taught to respect ourselves and to invite respect to the profession.
Okay.
The competence of each of them the competence, the legal competence, and I'm saying this without any fear of favor, the legal competence of either of them is not in question. It is the moral attitude of one of them which is in question now. Okay? And so for me, that is not what is the subject of the committee's inquiry.
Okay.
So it is a mark of discipline to wean yourself or purge yourself of partisan political inclinations or emotions when you are dealing with professional matters. And that is what I am seeing is not at play. So if I ask them to stop, I am asking them to stop in the interest of our profession, and I'm asking them to stop in the interest. I know people are enjoying it, and you can see we lawyers somewhat we write well, which is palatable to the mind. And I know people will enjoy it. But of course, this is not what you should be enjoying. You should probably be enjoying their professional display in court. And so, yes, and so if you want to listen to them in court, that's fine. But I can tell you, either of them, both lawyers are very competent professionals. Okay? Their law is good. I mean, no one can deny that. Of course, there are some few instances that partisan emotions and partisanship can carry you away from your professional mind and cause you to do certain things that will be outrageous, in the face of the law. Yes, I can say Dami has probably done some things like that. And that's what one of the things I'm saying is to cite fundamental human rights issues and wanting the Supreme Court to enforce them when the Constitution has exclusively preserved that for the High Court. You see, but this, I can see it is not him. It is because of his probably motivations, inner motivations, which I can't tell. But I still believe that both of them are legally, professionally competent. They are good lawyers. Nobody can deny that. And so they should stop attacking themselves and just focus on the issues. They should teach the public. They should teach the public the things that the Constitution requires to be done, the standards of the Constitution, the expectation of the Constitution, and the framers of the Constitution. That is what they should be teaching us.
Okay. Thank you very much, as always.
Most welcome.
And I wish you the best of the week. That's lawyer ALHASSAN Osman joining us on the line for a conversation on this issue that will never go away. Don't forget, the Chief Justice has a case before the courts, and then there's Godfrey Dami, who is also now facing a petition from a private individual who is asking that something that was ignored when he was Attorney General should be dealt with now to set the appropriate examples. Before we take